Well, let's get into our first topic, death and probate issues. Question number one, if Mary dies, will her estate have to go through probate? Now, we give you a hint. I want you to check the asset listing on page 1 of the blue sheets. And after checking that asset listing, tell me whether or not you think Mary's estate will have to go through probate if she dies first. Anybody want to venture a guess? I hear some no's. Do I hear a yes? Yes. I hear a yes. Why do you think the estate would have to go through probate if Mary died?
I don't know what the maximum limits are.
So you think there's some maximum dollar limit that might apply and force the estate through probate? That's almost correct. Anybody have another theory on why the estate would or would not go through probate?
Will.
Because there's a will? Well, you don't know that. Well, we haven't told you that yet. You don't know whether Mary has a will, so that's not a factor. Well, what we've got on this asset listing are a number of joint assets. The house, the Hawaiian condo that they use for vacation, and some mutual funds. What happens when folks die owning jointly owned property? It'll pass directly to the surviving joint owner. So those assets will simply avoid probate. The other assets, like insurance, IRAs, and annuities, will pass to whomever is named as the beneficiary on those accounts, probate free. And some of the little assets, personal effects, automobiles, generally escape probate altogether. And you'll see why as I describe the $50,000 rule to you in just a few minutes. So the answer to this question number one is no. Mary's estate won't go through probate. If Mary owned the Hawaiian vacation condo in her own name and then she died, would her estate have to go through probate? How many people say yes? How many people say no? How many people don't know? And how many people don't care? The answer is clearly yes. When you own real estate in your own name, it's going to go through probate when you die. If John, husband John, died a year after Mary, and he left everything to his 2 children in his old will, would his estate have to go through probate? What do you think?
Yes.
Most people say yes. How many people say no? Why do you say no, young lady?
Because there is a will.
Because there is a will, she says. What's wrong with that statement? Well, unfortunately, and contrary to popular belief, wills do not avoid probate. They never have, they never will, and they were never intended to. Therefore, this estate, when John dies, will go through probate. The existence of the will does not change that result. So, major lesson number one today. Wills do not avoid probate. And if you have one now, thinking it was the answer to avoiding probate, I'm sorry to disappoint you, but that's not the answer. How many estates will John's estate have to go through probate? How many states then? 2 states. Why? Because he owns real estate in 2 states, Hawaii and Colorado. And what do you think it's going to cost the kids to settle this estate, which is really a pretty simple, modest estate, relatively speaking? Well, it's hard to tell and pin down the cost exactly, but I think this $10,000 figure, give or take a few bucks, is probably fairly conservative. There will be 2 court proceedings, 2 probates, and 2 opportunities for the family to have to deal with 2 sets of probate lawyers. So I want you to beware. There will be a probate in every state where property is owned by a decedent in his or her own name. Can I see a show of hands of folks that own real estate in more than one state? 1, 2, 3, 4, 5, 6, 7, 8. All right, that's a problem that you're going to need to fix, and you'll learn how to do that today. Let's assume now, under number 5, that John and Mary had old wills that left everything when they both died to their separate children 50-50. Could John change his will after Mary's death? Sure, why not? Could John change his will after Mary's death and leave 100% of his estate to his daughter only, to the exclusion of Mary's son, Bart? Absolutely. If John got remarried after Mary's death, could he change his will again and leave everything to his new spouse, Carmen, and cut out both of the kids? In a heartbeat. And these types of things don't just happen on days of our lives. They happen right here in North Glen, Denver, Boulder, Pueblo, you name it, all over the place. If Mary were made aware of how John could change his will after her death, do you think she might be just a little bit worried that her son could get cut out? And if John started thinking about it too, do you think that he might be a little bit worried if he died first and Mary died second, maybe she could change the will and cut out his daughter Alice? Absolutely. Number 9, what important legal document then should John and Mary have in place that would guarantee that the surviving spouse wouldn't disinherit the child of the first spouse?